sponsored by the law offices of Joe Pippen. Learn more at ATTYPIP.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now in Tampa. Call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open early on a Saturday morning just for you. If you have a legal question, it can be just about any area of law. It can be about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates, just about any problem you have. It doesn't even have to be a legal question. I'd love to help you. And the whole purpose of the show is to help as many people as I can in the 50-minute straight non-commercial run here on time. And all you have to do is to call the toll-free number. I always like that first caller coming in, 877-943-9673. 877-943-9673. And our phone lines are very much open for you. Maybe you've been worried about something. You kept waking up during the middle of the night, worried about some legal issue. Something on your mind for a long time. Somebody's just not treating you right. Something doesn't seem fair. Hey, give me a call. Let's talk about it. And maybe I can give you a little peace of mind, get you pointed in the right direction. Again, I'm Attorney Joe Pippen, host of Ask an Attorney, all about Florida law for over 37 years and running now. Longest running continual show in Florida, as far as I know. I don't know any other show that's been on anywhere near 37 continual years. Same host, same format. So if you have a question, give me a call, 877-943-9673. Let's go to Judd in McKinley, Florida.
Yes, sir.
Where is McKinley in Florida? What's it close to? Are you there?
Yes, sir. I'm sorry.
Yeah.
You're breaking up. Yes, sir.
Okay, what can I do for you?
I have a question. We currently are trying to get custody of our grandchildren, and we've paid an attorney $2,000, and he pretty much hasn't done anything. And now come to find out that he no longer works for the firm, and we're out $2,000. I just don't know what to do from here.
Well, you've completely lost contact with the attorney?
No, actually, well, the attorney's office that we do still talk to saying we still owe another $1,000 for them to continue our case, but we've already have a signed agreement for $2,000 for them to help us and do what they need to do. And the guy that was helping us actually no longer works there.
Yeah, but the contract is with the firm.
Yeah, it was confirmed for $2,000. We signed it, had it notarized, everything, but now they're saying they need another $1,000, and they haven't even really done anything.
But the contract itself is with the firm, not the one attorney.
Yes, sir. It's not the person. It's with the firm. Yes, sir.
And you paid the whole $2,000?
Yeah, we paid the whole $2,000. We have proof through the bank.
Okay, so I think you should probably at this point go to another family law attorney, take the contract that you signed with you, and let them deal with the other attorney about the compensation and so forth. And then maybe have the attorney write a letter if you want to change attorneys at this point. I know. I think a new family law attorney should review the contract and discuss with you your options. I think, the general answer is if you've done everything yourself and you don't have a good result, and it sounds like you've done everything you can, you don't have a good result and everything's at a standstill and it's not going to move forward until something happens. And I think that's something that should happen is you have a discussion with another family law attorney. Let them analyze your contract, look and see what's done, and then maybe write a letter to the firm, asking for a refund or a partial refund, and then proceed with someone else.
Okay. All right. That's exactly what we'll do then. So, because it's so frustrating. It's been a year and a half, so pretty much almost a year and a half. But and the kids got to start school in August. We're like, we don't know what to do because we can't start school without temporary custody. All righty. Well, thank you very much, and that's exactly what I'll do.
All right. Good luck to you.
All right. You too. Thank you.
All right. Thank you. All right. You're listening to Ask an Attorney all about Florida law. If I can help you, all you have to do is call our toll-free number, 877-943-9673. Hey, your question helps a lot of other people, believe it or not. And a lot of people are stuck in a situation and not knowing what to do. And they listen to a show like this and get some information and maybe a different approach or a different idea and proceed forward. So, hey, don't be shy. Let me help you and help others that are listening. 877-943-9673. Phone lines are open. Let's go to Peggy in Clearwater.
Oh, hi. Can you hear me okay? I'm having trouble with reception here. Can you hear me okay?
Yes, I can hear you.
Good. Okay. So I'm a little bit ignorant in this manner, but I do have a question. I received a summons to appear in court. I received a summons representing American Express Company, the credit card division, I guess it is, to appear in court in February, in the beginning of February. And I'm moving, and I'm in total disarray. I don't even know where I put certain things to go back into storage to find them, or maybe not even in storage, maybe even he's still here in the house. But I cannot find it immediately, and it's coming up. The date is coming up. And I wanted to postpone it if possible because I am moving and also I'm handicapped and a lot of pain. And so I want to know what could they do to me if I don't contact them and change the date, or how can I even find out what the date is? It's in all I know is I guess their attorney is representing American Express, and just want to know what's the consequences if I don't show up for that summons date.
Well,
and the date it's just the first it's what am I saying? It's the first step in the process that they use, the summons, I guess, and then they sent a letter. And then
okay, I understand your question. So the answer is, if you don't show up, they could possibly on the is it small claims court or regular court? How much money is owed?
I think it's from a credit card, and I think it's less than $2,000.
Yeah, so most likely it's small claims court.
Okay, I think so. Yeah, and I think it was Tampa.
Ma'am, okay. Well, ma'am, first of all, you can call the clerk of the court in Pinellas County. Tell them your name. Tell them you've lost your papers or can't. You know, at the present time you can't find your papers, and you want to know your court date. The clerk of the small claims court can give you that information. You can ask the clerk of the court if you could ask for a postponement, and do they have a form or something that you can sign asking for a rescheduling of the time.
Okay.
If the clerk says no, the clerk should be able to give you the name of the opposing attorney, and you can call the opposing attorney, since it's a small claims court, and ask if they would be so kind as to reschedule the event.
Yeah. So should I just Google clerk of the county court in Pinellas County?
Yeah, and then you ask for the small claims. Some operator probably pick up the phone, and you ask to be transferred to the small claims court.
Small claims court?
Clerk,
okay.
Yes.
Clerk, sorry. Yeah. And then I'll do this. If it's not there, it most likely it's in the town or city that you live in, right? Because I don't live in Tampa.
Yeah.
I live in
Yeah, you probably got served to go into court in the county where you live.
Yeah, right.
All right.
Okay. All right, wait, don't hang up yet, because there was one more important thing. Oh, yeah, I'm moving because of financial problems that I'm having, and I'm moving for at least minimum of 3 months.
Mm-hmm.
I really don't want to give out my address where I'm living at.
Well, I don't need your address.
No, not you. But what I'm saying is the court date is in February. I will be at another residence for financial reasons in February and March as well. So I wanted to know. I don't think I can hardly drive. I don't think I'll be able to drive for that court date if it's still the same court date. So that's why I want to.
Ma'am, you're going to have to work this out with the opposing attorney.
With the opposing attorney?
Yeah.
Okay.
Do you owe the money?
Not the attorney, but the
No, do you owe the money to American Express?
Yes.
Okay. Well, if you never showed up or they can't find you and you move and don't give anyone your address, the court will eventually move to get a judgment against you.
Yeah.
And then they'll just work on collecting on the judgment. If you don't have any funds at all, they have nothing to collect it against. There are certain things that you have that might be protected, like Social Security or disability money is probably protected. All right, Peggy, I'm going to move on to my next caller. I hope I helped you. Thank you. Let's go to Joey in Sarasota. Joey in Sarasota is gone, I guess. Right? It's gone. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. If you have a legal question, if I can help you, all you have to do is to dial the toll-free number, which is 877-943-9673. That's 877-943-9673. Had an interesting discussion with a client this week about who should be the successor trustee of their trust. Same answer would probably apply to if you had a will, personal representative, executor. Should you have two people together? Well, the answer is the positive things about two people for your benefit probably would be that there's a check and balance on everything that gets done. The minus aspect of that is because there are two people have to sign everything. In this particular case, they didn't live anywhere close to one another. So it slows down the process. So you have two things to consider: slowing down the process. Is that okay? And the positive thing about a check and balance on one another and making sure there's an agreement about things that get done. Let's go to Joey in Sarasota. Hey, Joey.
Hello.
Hi.
Can you hear me?
Yes.
Oh, okay. I cut off the first time. I was calling because I'm the executive of my mom's estate, her trust, and there's 5 of us, and we're selling the house, and it would be divided equally. And I was wondering, what kind of tax reporting do we need to do, and is there any IRS reporting?
Well, the estate in general should have an estate tax return.
Okay.
There probably won't be any taxes due. The real estate gets a stepped-up cost basis at time of death, meaning that if your mother paid $100 for it and you sold it for $200, there's no capital gains tax, and there's no tax equally if it's $40,000 to each beneficiary. There's no tax to them. So you probably just have the formality of the tax returns done without any taxes due. And that's something that an accountant or CPA, you should have one for the estate to advise you and maybe do the last return and get a tax number for the estate and so forth.
Okay, I think we have a tax number, and you said 40,000. I think there's going to be.
No, I was just using example numbers. I mean,
okay.
I have no idea of what your estate, the estate's worth.
It's only about 300,000 for 5. Divided into.
Yeah, well, minus expenses. If there were no expenses, it'd be 60,000 a person for 5.
Right. Okay, well then I know that we have a form for the IRS that we had to file at the time that we got the trust, so we have that. So that way we would file a tax return with the IRS on the estate.
Yeah. Are you going to take a fee for your services?
No.
See, if you took a fee, that would be income taxable to you.
Okay, no, we're just going to divide it evenly.
Well,
So,
you're entitled to a fee now. Did you have an attorney?
I know. Everybody's worked hard on everything else, so we'll just split it evenly.
Did you have an attorney in the process?
He retired.
Did someone else take over? Did you do a substitution of counsel in the case?
I'll have to check to see. I'll give a call or soon to.
So if an attorney opened the case, an attorney's going to have to close the case, most likely.
Okay. All right. Well, we'll do that then. I'll get in touch with the previous attorney and see who took over his practice.
Okay, very good.
Thank you very much.
All right, thanks. Thanks for calling.
Bye.
Let's go to Phil in Orange Park.
Good morning, Joe Pippen Law. Phil here. Sorry, my health has not been that well, but I have a question for you, and it's always a pleasure to listen to you, knowledge-wise and whatnot, and you're savvy. And I'll tell you what, I'm looking forward to, I don't know if I'll be around another 30 years, you on the air. I think you ought to go global, but we'll work on that, okay?
I was nationally syndicated for 2 years a while ago.
Wow. How did that go? That makes you a very busy camper with the different time zones and everything, that's for sure.
Well, the problem with that, I was offered that. It didn't really cost me anything, so I did it for about 2 years. But, after trying to answer questions in 50 states when I'm only licensed in one,
right,
I got to be where the answers were too general. So I really just thought I should just focus on Florida, and doing stations. So, but anyway, what can I do for you today?
Well, your previous caller gave me a question before my question about a trust. Okay, say someone deemed themselves executives of someone and the person died, so they're getting a fee. Now, did they deem themselves that fee? Let's say it's $25,000 each for two people, just as an example. Do they have to file taxes on that income?
If they took a fee, they do. If they take a distribution, they don't.
Okay, so as an executor, if you take a distribution or fee, it makes a difference on whether you file the tax. You need to file that as additional income for taxes, correct?
Yeah, the personal representative executor trustee is a job. So if you take a fee for doing your job, that's income taxable.
Okay, cool. Okay, now my question is, I have a dear soon-to-be 6-year-old lady friend, a good family friend, who has no husband, no kids, no bloodline heirs, and she's very solvent. And the question came up, she asked me last week, she said, Phil, I have everything in order from A to Z since 1950. However, my house now, instead of being worth $50,000, is worth $1.5 million. My property's worth $1 million, et cetera, et cetera. Do I need to have two trust funds? And she is, like myself, leaving a lot to charity. And as far as I know, unless you go over to $13.5 million, I don't think you need two trust funds.
Anything you leave to charity reduces the size of your taxable estate anyway.
Okay. Because I have probably 80% of my estate is going to charity the day after I die.
Does your friend have a trust?
Oh yes.
Okay.
She has a living trust, and she has her government pensions and everything, all in her assets, rural farmlands, et cetera, all in there. And she's pretty covered. I have not looked at it, but we talk like you and I talk as good friends also, and I mean that politely. But she said, it came up at the ladies group the other day at the beauty parlor. We're social distancing. What constitutes a second trust? I said, well...
No, she doesn't need one. She don't. If she's... Anything.
They don't get up early on Saturday. I'm trying to get them all, because you have another 190 women from Northeast Florida listening to you but at 8 a.m. on Saturday. They don't get up that early. They don't get up before 9. So anyway, so you were saying, so like with mine, 80% of which is, probably 2/3 of $25 million is going to good causes and pension funds and charities as gifts.
Yeah.
So, and my local attorney, whom I knew her dad well, who passed away, who handled my uncle's trust and my parents' trust, handled all that, and I'm happy with it. What would constitute a second trust? Is there?
You don't need one. It doesn't sound like she needs one.
Okay, but what would? Just as an example, in my curiosity now, my mind's...
a second trust usually comes in between husband and wife.
Oh, okay, family members.
Yeah,
okay.
Because they don't want to, one die, leave everything to the other one, then the other one, the last remaining one, has a taxable estate.
Fantastic.
You'd have two trusts between husband and wife. If they have more than $11.5 million to protect two exemptions, but you don't need two exemptions. As a single person, you only get one exemption, and if you give 80% to charity, you're going to get that discounts the total amount down to an amount under the taxable limit. So I don't think taxes are an issue.
Fantastic. And real quick, something different. My grandmother died in 1972. She left me a PF Flyer shoebox. I never opened it. It was just relics of memorabilia and whatnot. You're not going to believe what I found in the box a couple of weeks ago. I had to go to a coin dealer to get it appraised. 1776, 1777, 1778, 1779, and before 1776, a wooden coin, original silver dollars, and the 1776 one in mint condition. The guy pulled his out of the safe. He said, "Turn it around, Phil." And on the back, $65,000. All those coins are worth about $175,000.
Wow.
I'm not selling them. I'm going to leave them to someone, maybe Joe Pippen law, who knows. But in memory of my grandmother and your grandmother, let me get going. And I appreciate your time. I didn't mean to take up too much time, but health has been a very challenge, so your prayers are welcome with everybody else.
All right, Phil. We'll certainly pray for you. All right. All right, thanks. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. If you have a legal question, we're about halfway through the show now. And you have a toll-free number if you want to call the show at 877-943-9673. Let's go to Michael in Sarasota.
Good morning, Joe.
Good morning,
My
Michael.
wife and I recently purchased our new first home, and our second home we're renting. We're debating whether to put it into a trust. We have 2 adult children with the beneficiaries versus transferring the title to the 2 children as joint owners. Any suggestions?
I would do the trust, because if you transfer to the children as a joint owner and one of the children got sued, divorced, had an accident of some type, you could lose the property if it's not the homestead property.
Right.
If the homestead property, you don't want to put multiple names on there if they don't live there, because then you could lose part of your homestead exemption.
Right. It's not a homestead anymore. It's now our second home, but we're not looking to keep it or do anything with it.
I
So
just
a
put
trust
it in a
is
trust and
easy
leave it to
paperwork.
them. Leave them upon death. You get a whole stepped-up cost basis. It's just a better way to do it.
Well, thank you very much, and I enjoy your show.
All right, thank you. Listen, you ask an attorney if you have a legal question. Again, 877-943-9673. Let's go to Chris in Tampa.
Hey, good morning. How are you?
Doing good, and you?
I'm doing great, thank you. Hey, I've got a rental property that the gentleman fell behind on rent in January of last year, and then we started a payment plan, and then as far as March went, when the COVID virus hit, they have a moratorium on evictions, and so he hasn't paid since January of last year. I did file to have him evicted prior to March. However, it's just sitting in the courts, not with no dates. Is there any repercussions that I have, or do I just have to wait for the government to lift the ban on getting him out, seeing that he just decides that he doesn't want to pay rent anymore? So it's $1,000 out of my pocket every month, and it's been over a year.
Yeah, I think you're probably going to have to wait till they lift the ban. But I don't do evictions. If you want to contact me, I have an attorney that spends a lot of time in that area, foreclosures and evictions. I could send you his name and address, or I could send you his email address and phone number if you want to email me.
Okay, I do have a local attorney here in Tampa, but again, he kind of is super busy. He's got all of his cases are backed up. I was just wondering, the other question I had, is it possible to, since I can't evict him, is it possible to move a roommate in with him so that at least you have someone paying rent?
Well, it depends on, would he be agreeable to it?
No, he's not agreeable to pay rent.
Yeah, no, I doubt that you could do that. I mean, I'd have to see the lease, but I don't think so.
There is no. That's the other thing. There is no lease. I leased it to his girlfriend. She moved out. He moved in, and now he's a roach. He just won't leave the property. It's basically a squatter.
So, okay, and your attorney, did they help you file the eviction?
They did.
And they're telling you there's nothing you can do now?
Correct.
What do you think would happen if you, since he's a squatter, and there's no lease agreement, and he's never paid you rent?
No, his girlfriend did, but they've since broken up, and she's out of the picture now.
What do you think would happen if you went and just changed the locks on the door when he wasn't there one day?
I don't know if that's legal. I'm not sure. I don't know. I don't know the law. I'm not an attorney. So.
What's he going to say? Tell the court I'm a roach and I deserve to be back in there? I was trying to be funny, but I don't know. The lease is with someone else who vacated the property. So basically, if he's never part of the lease and has never paid rent, I would get aggressive with him because he's actually stealing from you.
Right.
And I don't know what's a court going to do to you if you go change the locks on your own property. I don't know. Something to think about. If I were you, I would ask your attorney, since you have an attorney. I don't want to get involved with ethical problems here, giving you advice when you have an attorney. Ask your attorney what would happen if you change the locks on the property and see what he says.
That I will do. I appreciate your help. Thank you so much.
All right. Thank you.
All right.
All right. Phone lines are open again at 877-943-9673. Let's go to Jim in Jacksonville.
Hello.
Hey, Jim.
How are you?
I'm doing good, and you?
I'm doing good. My question is regarding, I believe, a trust.
Mm-hmm.
I have three grandchildren that are college age, and I would like to give them some stock maybe 10 years from now. And I'm trying to find out, since I presently own stock, am I better to create a trust for each child so that they can't take the money or they can't take the stock if I put it over in their names and go buy whatever they wanted to go buy, or how would I try to resolve that issue?
Well, if you put it in their names, it's gone. They can do whatever they want to with it, sell it and so forth. If you put it in a trust, you can say any interest in ABC stock to, number one grandchild at the age of, you can put the age, or, 10 years after my death, you can put whatever language in the trust you want to when they get it. And
okay.
you can go ahead.
I already have a trust. Okay. So can I just use the trust that I presently have to designate this and just put it an amendment in my trust, or do I need to create a?
No, sir. Okay. You can most likely your trust is a revocable trust. You can amend, change, revoke the trust, and you can do an amendment.
Right.
You can do an amendment to the distribution clause. To do what you want to do for your grandchildren.
Okay, very good. All right. Thank you very much.
Yeah. So you still have a good relationship with your existing attorney that did the trust for you?
Yeah, I guess so. I mean, I haven't spoken to him in 4 or 5 years. But
okay.
I just get a letter every year saying, any changes.
Yeah, that's right. Well, yeah. Okay, well, that works. Just go back, ask that attorney to do an amendment for you concerning your grandchildren, and they should be able to amend that trust.
Okay, great. Okay, thank you.
All right, thank you. All right, you're listening to Ask an Attorney all about Florida law. If you have a legal question, you have a toll-free number. We have 21 minutes left in the show. And you have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Hey, we have multiple locations around Florida. And if you're listening to a local station, we probably have an office in your area. So we have 2 offices in Pinellas, 2 in Polk, 2 in Pasco. We have offices in Lakewood Ranch. We have office in Jacksonville. We have an office in Clermont, Leesburg, the Villages, in Payne City, Lakeland. We have multiple offices around the state of Florida. We don't charge a fee for the first visit to review documents. So, for example, if you have a trust or a will you want it reviewed, we would review it. And a lot of people come in with documents from other states. We review those. There's no fee for that first visit to review those type of documents and make recommendations to you. We have a flat fee schedule. So like an amendment to a trust is $150. If you created a new trust and you're a single person, it's $795. That includes a trust, a will, a power of attorney, healthcare surrogate, living will, deed of your residence to the trust. If you're a married couple, it's $895. All of our fees are posted on our website, which is attypip.com. That's attypip.com. If you want to send me an email, it's joe@attypip.com. Last year, we're going to get this cranked up. I know I keep saying this pretty soon again this year. We're going to do some Zoom seminars. We had a series of 7 Zoom seminars last year. We did them every other week. And they're available for you if you want to see a seminar on a particular topic. Here are the 7 topics that we did. We did a topic on living trust. We did a topic on probate. We did a topic on Medicaid. We did a topic on asset protection. We did a topic on family law and guns. If you like any one of those links or all of them, just send me an email and we'll send them to you if you want to learn more about one of those topics there. And you send it to Joe, Joe, at attypip.com. Let's go to Joe in Ruskin. Joe, are you there? Joe from Ruskin, are you there?
Yes. Can you hear me?
Yes, go ahead.
Okay, a couple of quick questions. I have a will and a trust for my 2 kids, and all of a sudden we popped up a granddaughter. The questions would be, if I were to take some stocks, can I put it in her name? Does she need an overseer, being she's like 3 or 4 months old?
Well, I wouldn't put stock in her name. I would just leave her stock from your trust.
Okay. And the other question is, I've got some freestanding stock, which is not in an IRA or a 401 stuff. Can I just take my name off of it and put her name onto it, or that's not copacetic?
You know, if you give her more than $15,000, you'd be making a gift. She can't really be the owner and do anything with it because she's not going to be of age till 18. So anything you want to give her, I would just put it in, state what you want to do for her in the trust, and give it to her. Give it to her at a certain age, like 21 or 25, but make it available for college, medical, education, maintenance expenses before that.
So I'd have to have an amendment because she wasn't here when I wrote there when we had the will and the trust set up. Just call the lawyer and say include her in.
They do an amendment to your trust.
Okay, and that way she could have it
at whatever age you pick. I wouldn't give a youngster too much money to learn a little bit more about them. You know,
correct.
You don't know who their friends are going to be. You don't know what bad habits they're going to be. You don't know how responsible they're going to be. So it's usually better to restrict it till 21, 25, but have it used for certain purposes like education, medical, things like that.
Okay. So put it in her name in the trust and then state an age which she can actually tap it.
Put language in the trust as to what you want her to have and when she gets it.
Okay, and so the other 2 that are in there, so now there would basically be 3 in it.
Yeah, it could be 3 equal shares, or it could be 10%, 45-45. It could be whatever you want. Now keep in mind, here's something to think about though. You're giving. How old are you?
I'm 75.
Okay. So let's say you die. I'm just making up an example. So you die when you're 80, and you give a substantial amount of money to somebody who's going to be 6. So it's going to be managed in this trust until they're 21 or 25. But that's a job for somebody to manage that money until your granddaughter becomes of age.
Okay.
So that's something to discuss with. Is your attorney local that did the trust for you?
This one down here, yes.
Okay.
He's over here in Ruskin someplace.
All right. We'll go back to that attorney if you're happy with that attorney and just discuss all of these issues with him. But there is something to think about. On the successor trustee has a job to do, managing this money for the granddaughter for a certain amount of time. Okay?
Yeah, okay. Yeah, it just popped up, so I've been thinking of what to do or whatever. But, yeah, I can do that.
All right.
Very good.
All right, very good. Thank you. All right.
Thank you. Bye.
Let's go to Robert in Newport Richey.
Interested, a single woman who's dying and has only nephews and niece and cousins surviving. Is there a hierarchy of beneficiaries, potential ones? The only assets are a small mortgage she holds.
Okay, she has no will or trust?
No.
And you don't think she's going to create one?
No, the only assets are the mortgage.
Yeah, but you don't think she's going to create a will or a trust?
I don't think so.
Okay. Okay, so she has no spouse, right?
Correct.
No children?
No.
And parents are not living?
No, only cousins and nieces and nephews.
The hierarchy of distribution, as you asked, would be the nieces and nephews.
Yeah, or cousins.
Nieces and nephews is the answer.
I see, not cousins.
Nope.
I see. I thank you. And in what order would that be?
Equally divided between the surviving nieces and nephews.
Divided equally.
So she had no brothers or sisters. I'm sorry, I skipped over a level here. No brothers or sisters either?
Right. No, only in-law.
Okay, but brothers and sisters had children?
No children. No.
No, the brothers and sisters didn't have children? Because they would be the nieces or nephews.
Yeah, the brother has children.
Okay, though it would go to the nieces and nephews is the answer, okay?
I see. Thank you.
Bye-bye.
Either side, maternal or otherwise.
Yes, nieces and nephews of the brothers and sisters.
Thank you.
All right, let's go to Nancy.
Hi, thank you for taking my call. I'm trying to help out a friend of mine who is trying to collect a life insurance policy on her brother who passed away back in September with the company Prudential, and they're extending this on and on. It's been like 5 months, and the proceeds are only $15,000, and the beneficiary to the policy was her brother's parents. So is there any form or any way she can expedite trying to get this, $15,000 from Prudential?
All right, so this person we're talking about is the direct beneficiary of an insurance policy?
No, her parents were the beneficiary.
Oh, I see. And her parents are both deceased?
Correct.
Well, her parents' estate's going to have to be probated. If there's no contingent, the beneficiary was parents, and if there's no contingent beneficiary and both of the parents are deceased, then it's going to be in the parents' probate estate. And that's why it's taking so long. So the child of the deceased parents who thinks they're in line for this money would have to hire an attorney to start a probate proceeding.
For as minimal as $15,000?
Yes. Because it's in a deceased person's name.
A probate estate in the deceased person's name.
Yeah, so the last parent to die, most likely their estate is going to have to go through probate where someone appointed to be able to collect assets that are in their name or beneficiary of to be able to give the insurance company a letter of administration authorizing them to collect that money, which all of that is a probate proceeding.
I see. Is there any... I was reading any, what is the terminology for a person who doesn't have much money or some kind of emergency release? I don't know the name of what I'm talking about. That you can avoid probate. Is there any way to avoid probate?
Not if the asset is already in a deceased person's name, which it sounds like it is.
Right, the asset is in her brother's name who is deceased, and her parents are deceased. So the insurance company just can't send the next of kin a check. It has to go to probate, you're saying.
That's correct. Are you calling? Okay. Are you calling from Boston?
Correct. Yes.
So you're listening to the show on your computer or what?
No, I live in Boston, but I'm in Florida right now.
Oh, I see. Okay.
Yeah, I live in Boston.
All right.
I'm just here visiting. Okay. Thank you very much.
All right. Thank you.
Bye-bye.
All right. Let's go to John in Lake Wales.
Hi, thanks for taking my call. I just have a simple question, I think. I've heard about a Ladybird deed, and I'm wondering what's the purpose of that, and how do you get a form or whatever you need, and then the procedure to.
Well, I don't think you're going to get a form per se. An attorney can prepare a Ladybird deed for you if you choose to. The purpose of a Ladybird deed is to take a property. Basically, you, the owner, with the beneficiary named on the property upon death, so the real estate has a way of avoiding probate. Having said that, I think the better way to avoid probate generally is a living trust, where you can put your deed, instead of a Ladybird deed, you put your deed into a trust. You have other assets that can go into a trust. The successor trustee that you name to handle things upon your death or incapacity can handle those things. And the big benefit is upon incapacity. With a Ladybird deed, nothing really happens until death. With a trust, the successor trustee can manage everything for your benefit and the lifestyle to your custom while you're living, but maybe perhaps incapacitated.
Okay.
So a better way to avoid probate, I think, is a trust, not a Ladybird deed, in my opinion.
All right. Well, we have very limited asset, just basically the house, and we're paying on it. So I felt for people like the people I've heard calling with millions of dollars, and that's
yeah. But if you had a minimal estate with a minimal fee on probate, even if it's a really, really small amount, it's $2,500, and it's between $2,500 and $3,500 actually, and the court costs are $500 or $600. And you can do a trust for a package with a trust, a will, a power of attorney, healthcare surrogate, living will, a deed of your property into the trust for like $795.
Okay.
And it covers all of your assets, not just your deed. So.
Okay. Well, we'll look into that then. All right. I appreciate the time.
All right.
Take care.
Thank you. So anyone out there would like to look into that, we have a free estate planning poster sheet that we'd be glad to mail to you. You could also ask for the link on the Zoom seminars we did on estate planning. And if you'd like to get either one of those or both, you could send me an email to Joe, Joe, at attypip.com. That's Joe at attypip.com. Hey, by the way, today you could have been watching, I should have mentioned this earlier, you could have been watching the show on the video on webeamtv.com. And by the way, they have a lot of the shows on their network that you can access from the past and watch current shows on Saturday morning every other week. We do WeBeam TV Live. It's also on Facebook. Now, if you'd like to join me on Facebook, I have a personal page, a Law Offices of Joseph Pippen page, and an Ask an Attorney page. So if you want to find me, just look for Joseph Pippen, Law Offices of Joseph Pippen, or Ask an Attorney. And we can connect there, and then you'll be in line to maybe watch shows a little bit easier. Or, and like today's show will be reposted on, so you can watch it a little bit later today. In fact, right after the show's over, they repost it pretty fast, or I will, so you can be able to watch the show. Maybe you would like to see me see me answer your question rather than just hear it. Hey, so we have about 5 minutes left in the show. You have a toll-free number if you want to call the show. We have time for at least one or two more calls at 877. And phone lines are wide open right now. 877-943-9673. That's 877-943-9673. And phone lines are open. So I get a question once in a while. Suppose a person has a living trust, and this is actually an actual question that happened this week. So Suppose a person has a living trust and they have all of their assets, or the bank accounts, stocks, bonds, real estate, everything is in the trust just like it should be. And they are in a terrible car accident and get killed. And someone else is at fault. So does the money from the personal injury lawsuit, wrongful death lawsuit, automatically jump into the trust? The answer is no. In fact, the personal representative has to be appointed to even be able to, of the will that's nominated in the will has to be appointed to be able to file a lawsuit for the purpose of the estate. And then the check's going to be made payable to the estate, which means you have to probate just that one asset now, the wrongful death claim. It's nothing automatic. So the wrongful death claim will be made payable to the estate of the deceased person and not the person's trust. Just a question, a little information for you. Let's go to Brett in Tampa.
Oh, yeah, thanks for taking the call. I had a question. My mother-in-law's husband died 5 or 6 years ago, and he had a trust set up with the house and all his stuff in her name.
Mm-hmm.
Now, she never put that into her name. And I'm just wondering what the options are. Now, if she passes away...
If she dies with an asset in a deceased person's name, it's going to go through probate.
Okay. All right. And then, so your company does that, right?
We do wills and trusts to avoid probate, but we also do probate. Yes, sir.
All right, perfect. And you're in Largo, Florida?
We have multiple offices, so yes, we have an office in Largo. We have several offices in Hillsborough as well.
Oh, perfect. Okay. Thank you very much.
All right, thank you.
Bye.
Let's go to Tammy in Haines City.
Hi.
Hey, Tammy.
Hi. I've got a question. If you add your kids to your deed using a Ladybird deed, does a gift occur at that time?
No, the gift, no, it doesn't.
So at date of death then, would the kids get the step up in basis?
Yes.
Well, thank you very much for your help. I appreciate it.
All right, thank you.
Bye.
All right, let's go to David in Bradenton.
Yeah, good morning, sir. I have a question regarding a will. One is deployed, and he has a couple of properties, and he's currently in the country in Florida, and he wants to have a will. I am his only next of kin, no father, no mother, no kids involved, no wife, nothing. And he's leaving on Tuesday, this Tuesday. I mean, the coming Tuesday, on the 26th. Is it possible to draft something and have him sign on it with that little time, or what do you think?
He's in Bradenton?
Yeah.
Could he come to Largo on Monday?
On Monday, what time?
Well, I don't know. I'm just saying. What he needs to do is to call me on the phone. I take his call this weekend.
Okay.
I can have papers ready for him, and then we can figure out where to meet me. So if you want to give him, I only got a minute here, so we have to write fast. My phone number is 727, cell number.
727
667
667
3967.
3967. Thank you so much.
All right, thank you. All right, let's go to Judith in Sun City Center. We have a minute and 26 seconds, Judith. We got to go fast here.
Okay, I'm here.
Go ahead. We got a minute and 19 seconds right now, so we've got to speed this up properly. Or
okay,
you can call me. You can call me on my cell phone.
I'm here. My question is, but he's still talking. My question is, what is a Ladybird deed? I'm listening to the program, and I just heard him talk about that.
It's a deed where you have a beneficiary named on the deed itself. I think a trust is a far better, more efficient way of handling for estate planning. But a Ladybird deed is a deed with a beneficiary, basically.
A deed with a beneficiary.
Yep.
Okay, thank you. Am I speaking to Joe?
Yes.
Oh, okay, because I don't hear me on the radio. Thank you.
Thank
Bye.
you. All right. All right. Well, thank you for listening to Ask an Attorney All About Florida Law. We're here every Saturday morning at 8 o'clock. They rerun the show on 570, 910 a.m. in Tampa on 5 p.m. on Sundays. And but we're here every week, and we're glad to have you join the show. If you have a question come up Remember, Ask an Attorney all about Florida law on Saturday mornings at 8 o'clock. Hey, you have a great week. Go Bucks.